Hey guys, my name is Marcy Facio with Facio Law, and I am a criminal defense attorney in the Oklahoma City area. A lot of times when people first get arrested or charged with a crime, or they have a loved one who's been arrested or charged with a crime, the first question is you immediately want to know what's going to happen. And of course, I can't see the future. I don't have a crystal ball, but to kind of give you a little bit of guidance on what's going to happen, there's basically 4 different ways that a case can be resolved. And I'd say 99.9% of criminal cases that are filed in Oklahoma are resolved in one of these 4 ways. So hopefully by kind of walking you through this, it's going to help you feel maybe a little bit more comfortable, take a little bit of the stress off, because you at least have the parameters, the guidelines of how the case is going to end up. So like I said, there's basically 4 different ways that a case can be resolved. The first way is through what I call an agreed plea. And an agreed plea means that you and your defense attorney make an agreement with the prosecutor about how the case should be resolved. So you can basically, like I said, kind of negotiate the terms and agree this is how this case is going to be resolved. You're not fighting the case. Now, you're not fighting in the traditional sense. There's still certainly some, I don't want to use the word fighting, but there's still definitely some back and forth in the negotiating. You don't want to just certainly take the first deal the DA throws out there. So there's some back and forth and some negotiating to make sure you get the best deal possible. But ultimately, the way most cases are resolved is through an agreed plea, where you or the defendant, be that you or a loved one, and you have the advice of your counsel, your attorney, reach an agreement with the district attorney. The advantage to that is you guys all know going in what's going to happen. So you've kind of got that certainty. You may not like the deal though, so there's some options as well. The second way that cases are often resolved, and I'm talking about in Oklahoma, in state court or city court, the second way is through what's called a blind plea. And there may be different courthouses might use different terminology, but the general concept is the same. A blind plea is if you are not able to reach an agreement with the prosecutor about what the outcome should be, you don't think that outcome is good, you think you can get a better outcome or sentence from the judge, you can do a blind plea. So again, this is not fighting or contesting the charges. You're pleading guilty or no contest. I'm not going to go into the different pleas in this video, but basically you're not contesting or fighting the charges. You're just trying to get a better sentence than what the DA has offered. So for example, if the DA offered 2 years in prison, you might want to try to do a blind plea and see if the judge will give you probation. That's the sentence. Prison, probation, a fine, something like that. So that's a blind plea, again, where you're not contesting the charges. You admit that you did it, or you admit that the state has sufficient evidence, but you make an argument through your attorney to the judge for the sentence that you want. So you and your attorney would argue, just as an example, for probation. The prosecutor would argue for 2 years in prison, and the judge would decide what the sentence is. So the judge could give you 2 years in prison, could give you probation, could give you more or less, anything within the range of punishment for that particular charge that's set by statute. The judge would be able to have that entire range and give you anything, either what you ask for, what the prosecutor asked for, anything higher, lower, or in between. A lot of openness there. So that's why it's called a blind plea, because you don't know what you're going to get. You don't know what the sentence is going to be. You're blind to it. The third option is probably something you've heard about a lot, and that's a trial where you are contesting the charges. You want to fight the case. You want to go to jury and have evidence put on. The state has the burden to prove the case beyond a reasonable doubt, and a jury would find you guilty or not guilty. So again, that's fighting the charges, going to trial. There's certainly a lot of advantages and disadvantages, which in this video, I'm just talking about the 4 different ways a case could be resolved. So I'm not going really deep. I'll do a video later about a trial. But the main pros and cons of a trial, the advantage is if the evidence against you is weak and you win, the jury finds you not guilty, then obviously you're acquitted. You've been found not guilty. So there's no consequences. There's no sentence. The case is over. And so that's obviously the best possible outcome. The disadvantage to a trial, again, you don't know what's going to happen. You have no idea if they're going to find you guilty or what the sentence is going to be. So there's a lot of risk to going to a trial. For example, if the prosecutor has offered you probation and then you decide to go to trial and the jury finds you guilty and gives you 5 years in prison, so a lot of risk there. That's the main disadvantage. And then the fourth way Doesn't happen very often, but occasionally a case is dismissed. That can happen because there was like the police did something wrong, or the evidence against you was lost, or there's only one witness against you and that witness disappears. That sounded kind of creepy, like you're going to murder your witness, and I didn't mean it that way. But basically the prosecution can't find the witness that they need. Or again, if there was a bad search, a bad seizure, things like that, where a case is dismissed. Very, very occasionally, the prosecution will even agree to dismiss a case. So again, this doesn't happen very often, but it is a possibility of a way that a case can be resolved. So as just a recap, there are 4 ways that the vast majority, 99% of cases, are resolved in Oklahoma State Court and Municipal Court, and that is through an agreed plea with the district attorney, a blind plea where the judge decides the sentence. Those 2, you're not fighting the charges or contesting it. And the 3rd way is when you do want to fight the charges and contest the evidence, that's through a trial. And then very, very, very rarely, sometimes cases get dismissed. So even though it's rare, you definitely want to at least explore that option to make sure your attorney looks into it. So it doesn't happen very often, but you certainly want to explore it to see if your case and your situation is one that would fall under the dismissal category. If not, you've got the other 3 options to explore. So hopefully that gives you a little bit of guidance and insight as to what's going to happen if you or a loved one have been charged with a crime. Good luck.